We're joined by, as you may have seen in that welcoming slide, Mr. Ikeji, who is a legal practitioner. Thank you for coming on today.
Thank you, Champion, for having me.
Yeah, it's the tribunal judgments that we're examining today.
Yes.
Lots of commentary making the rounds. Strong ones from
Yes.
politicians, especially if it didn't go their way.
Yes.
But from what you've seen, you think they've got a point?
Well, of course, partisanship would always becloud their judgments. But as lawyers, it offers us opportunities, different opportunities at criticizing. That is the word I'd like to use. Criticizing or critiquing the decisions of the tribunals. It helps us. It helps enrich our knowledge of the law. It also helps us to look at some of the issues canvassed, how the judges treated the issues, and help us to also bring out our own opinions, sometimes different from the judges, because judges too were lawyers, and they also have like knowledge as lawyers too. And that would mean that as lawyers too, we may also have a different perspective, different viewpoints from some of the judges.
How does that work in the light of the fact that it's at the first instance for the governorship ones and you still can go to appeal?
Yes.
And so when you've not exhausted the entire ladder, upon what do you predicate their views?
Well, this time around for politicians, it's what I would rather call shenanigans. Trickery. It may just be to play on the minds of opponents that they've won, and to an extent also create this sense of rightness in terms of what the decision, the judgment is, so that when they are on appeal, it will be difficult or it will be easy to have this confidence that the decision of the tribunal at the lower court was right. So I think it's just a situation of mind game. But for critical analysis, you can criticize the decision of the judge at the lower court, at the Court of Appeal, and at the Supreme Court. Just like the Supreme Court held in Ikeji's case, we as lawyers, we have every right to criticize it respectfully, insofar as we don't agree with it, or if we agree with it, to highlight areas where we agree with it.
Like which areas do you agree or disagree?
In which of the judgments?
The Rivers case.
Is it the Supreme Court or the Tribunal?
The Tribunal.
The Tribunal. Well, there are two kernels upon which I think the panel based their decision, and that is that they didn't believe the witnesses of PDP, the witnesses of Wike. They felt that their body languages while testifying were not believable. The second kernel was the issue of card readers. Now, with regards to the non-believability of the witnesses of Wike, they also spoke that it was easy to believe the evidence of APC, given the fact that they showed that there was no election and there were various there were a series of irregularities, and even though they didn't go to the entire hog or majority of the polling units to get evidence, the little that they got, the documentary evidence, they felt it was better and stronger. The second kernel is the card reader, and that card reader is, in my view, a sore point, a sore commentary on both the electoral process and our law. I think, and I have made this point earlier on, that the issue of card reader it's good for us to have card readers, technologically speaking, a technology-based accreditation process. But before we embarked on that card reader, we ought to have put certain processes in place. And now some of these failures are showing themselves. For example, in the Electoral Act, what is regarded as the authentic form of accreditation is the register of voters. And now, if card reader decides that you are not a registered voter, and you are refused accreditation,
or the incident form,
because
when card reader fails,
the incident form,
you fulfill the incident forms.
The question arises: should it overrule the provision of the Electoral Act that provides that register of voters, when you present your card, your voter's card, to the electoral officer, he will cross-check with the register of voters whether your name is there, and if your name is there, he would give you a ballot paper.
The question we'll also ask on the back of that is, does the Electoral Act also recognize that there could be fake voter cards?
Of course, a lot of when you present fake voter card, the Electoral Act recognizes it. It's part of the irregularities. I think from section 120 to section 130 of the Electoral Act provides very different levels of conduct that will be regarded as crime, and under which you can question a petition in section 138. However, let's avert our minds to something. Where card reader is a product of electoral guideline, INEC guideline, where INEC guideline seems to run contrary or seems to want to supersede a clear provision of a law, the question would be which should supersede. Ordinarily, the law should supersede. In section 138 of subsection 2 of the Electoral Act, it was clearly stated that any directive and so on issued by INEC or any of its officials shall not serve as to overturn the contents or the provisions of the Electoral Act. In other words, even though section 153 empowers INEC to issue guidelines, this section 138 says that no such guidelines shall act as to override the provisions of the Electoral Act.
But was there any conflict?
Yes.
That conflict coming up now. In what instances have we
seen when a tribunal says that non-use of card reader should be a ground to nullify an election, and there are 4 grounds under section 138 to question a petition, to question an election. Non-use of card reader is not a ground, and that is the reason why subsection 2 of that section of section 138 has come out to say that anything outside of those 4 subsections, 4 grounds of questioning an election, should not serve to override the contents of the Electoral Act. The position is clear. The situation is very clear. Yes, card reader is good, but like I have always said, personally, I didn't get my card reader. As I speak to you, I don't have my card reader. My wife doesn't have
your voter card.
I'm sorry, my voter's card, my permanent voter's card. I don't have it. And so the question arises that if my name is on the register of voters, and I have the original voter's card that was given to me, and I cross-check and my name is there and I am the one, I can identify myself independently. Why should card reader or permanent voter's card deprive me of the right to vote? And the Electoral Act is clear about that. So what INEC ought to have done in the first place was to have provided for an amendment before the National Assembly of the Electoral Act to provide and allow for card readers and permanent voter's card.
To the extent that what, if you don't have your card reader?
To the extent that if the card reader, to the extent that it recognizes that the card reader shall be the only means by which accreditation process can be conducted.
But they said that if you don't find your
don't
PVC.
forget that INEC on that day did after the problems with the presidential election, INEC had said you can move the election till the next day when the card readers don't even work.
So it raises the question, why then are tribunals basing their decisions on card readers? That is the point. That is the question we have to ask. Of course, we still have options at appeal.
Shouldn't we be saying, because they gave them a leeway, that if it doesn't work today, then move it to the next day until the problem is fixed?
If that is the case, why is the issue of card reader a basis of nullifying an election? Or why should petitioners raise non-use of card reader or discrepancy in the number of card reader or the number of cards accredited through the card reader and the number of votes cast? Why should it be a ground for an election petition?
You don't think it's because it's foolproof?
That's the point. It's foolproof. Of the fact that it is foolproof has nothing to do with its legality or otherwise, or the fact that if it is contrary to a clear provision of the law, that the clear provisions of the law should supersede.
What weight of force is given to INEC's powers to issue guidelines and conduct elections?
The weight is as strong as its powers to conduct elections. They have absolute powers to issue guidelines, but those guidelines shall not be. Could
it be a grounds upon which elections are nullified if?
No.
If you beg your pardon, if they're not complied with, if the INEC guidelines
I've answered it. No. I already know where you're going to. No, it's not. It shouldn't be a ground where guidelines are not within the purview, within the contemplation of the 4 grounds enumerated under Section 138 of the Electoral Act. Then those guidelines cannot be a ground to nullify an election at best. At best, if it can add.
Is that what the Electoral Act says, or that's what you're saying?
The Electoral Act listed some grounds, 4 grounds, under which you can nullify an election or question an election. If a guideline is disobeyed, but by disobeying the guideline, you do not in any way come under any of those 4 grounds, you can't nullify an election. It is for INEC to find a way to ensure that some of the important aspects of its guidelines are incorporated into the Electoral Act so as not to serve as raising the guidelines into the realm, into the level of law.